Donald Trump gloating that the Supreme Court says Colorado cannot remove him from the ballot. I disagree with the ruling. I will explain why and also the ramification this ruling may have. Let me first go to Trump.
I want to start by thanking the Supreme Court for its unanimous decision today. It was a very important decision. We're very well crafted, and I think it will go a long way toward bringing our country together, which our country needs. And they worked long, they worked hard, and frankly, they worked very quickly on something that will be spoken about 100 years from now and 200 years from now. Extremely important. Essentially, you cannot take somebody out of a race because an opponent would like to have it that way. And it has nothing to do with the fact that it's the leading candidate, whether it was the leading candidate or a candidate that was well down on the totem pole. You cannot take somebody out of a race. The voters can take the person out of the race very quickly, but a court shouldn't be doing that, and the Supreme Court saw that.
Okay, here we go. So there's nuance here. When you hear the ruling, the reversal of Colorado, understand there's nuance, but the headline will say unanimous, but there is actually dissension. You have to read the summary judgment and some of the collective judgments of the justices. They actually disagree on some of the dynamics involved. We call that the mechanics of the law. So I will try my best to dissect it. Okay, so the Supreme Court on Monday unanimously reversed the Colorado court ruling that barred former President Donald Trump from appearing on the state's Republican presidential primary ballot because of a provision in the US Constitution on insurrection. The Supreme Court's ruling means that no other state can bar Trump or any other candidate from now on. We call that reciprocation. From a presidential ballot or election for Congress by invoking the insurrection clause, the Constitution, Section 3 of the 14th Amendment, which was adopted after the Civil War, that says no person can serve as an officer of the United States who, having previously taken an oath of federal office, engaged in insurrection or rebellion against the US. So let me go ahead and provide some context for this part. The court has made a very narrow ruling here. It ruled against the Colorado methodology. But there's another dynamic that has not been addressed. For example, if you are a convicted felon and you are serving a probated or a parole sentence, you are unable to vote in most states during the time of your penalty. Even if you owe money because of a conviction, you are not able to have your voting rights restored until all money is paid, even if you are off of parole or probation. These are state laws. These state laws that bar you from voting also bar you from, yes, running for political office. So is the court saying that Donald Trump, even if convicted for a felony, would be able to bypass the laws of every state and do what no citizen of any state has been able to do, and that is to run for elected office while currently under conviction and parole? There's more. Colorado was the first of 3 states to block Trump from a primary ballot on those grounds due to his alleged incitement of the January 6, 2021 riot at the US Capitol, which disrupted the confirmation of President Joe Biden's Electoral College victory over the incumbent, Trump. Quote, "We conclude that states may disqualify persons holding or attempting to hold state office." Keep that graphic up. The Constitution does not say this. It does not simply say state. I will explain in a moment. The Supreme Court said in its ruling Monday, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency, for the reasons given. Responsibility for enforcing Section 3 against federal office holders and candidates rest with Congress and not the states, the ruling said. The judgment of the Colorado Supreme Court therefore cannot stand. Allow me to provide some nuance to this. If you were to take this ruling in its current context, you would have to conclude that states are unable to enforce constitutional rights. Let me say that again. If you take the court's ruling at face value, you would have to conclude that states are unable to enforce constitutional rights or uphold them. Doesn't make sense, does it? States are able to uphold US constitutional rights, and they are able to uphold these rights within the context of their own state constitution as it relates to the reciprocation connected to the federal constitution, i.e. the US Constitution. This is an extreme ruling. This is a precedent, okay? So it's the argument of the court that a state cannot enforce the US Constitution. This would not make sense. I'm asking you to journey with me through the legal jargon here. States routinely uphold constitutional rights. And in the filing of Colorado, this was simply about the enforcement of a particular clause. Do states have the authority to enforce the US Constitution? Yes, they do. They do it every day. Ask any office holder, do they also enforce the US Constitution? Yes, it's by way of oath. There's more. The decision did not conclude one way or the other if Trump actually engaged in insurrection, as Colorado's high court did. Trump, who is the clear favorite to win the GOP presidential nomination, in a Truth Social post reacting to the ruling wrote, quote, "Big win for America." Later, during remarks from his home in Florida, Trump said, "The voters can take someone out of the race very quickly, but a court should not be doing that." And the Supreme Court said that very well. It was a very important decision, very well crafted, and I think it will go a long way toward bringing our country together, which our country needs. He said, Colorado Secretary of State Gina Griswold, in an interview with MSNBC after the ruling, said, quote, "My larger reaction is disappointment. I do believe that states should be able, under our Constitution, to bar oath-breaking insurrectionists." The president of a nonprofit advocacy group, Citizens for Responsibility and Ethics in Washington, which represented plaintiffs in the case, said the Supreme Court, quote, "failed to meet the moment by allowing Trump back into the ballot in Colorado, even as it did not exonerate him for engaging in insurrection. But it is now clear that Trump led the January 6th insurrection, and it will be up to the American people to ensure accountability," Crew Presidential Noah Bookbinder said. So he makes a good point. What is his point? His point is the Supreme Court has ruled that we must put this man back on the ballot without dismissing the ruling that he, in fact, engaged in insurrection. Why is that part important? Because a Colorado court has upheld that Donald Trump, in fact, engaged in an insurrection. The Supreme Court was well within their authority to overturn or basically moot the point of the Colorado court, clearing the way for Donald Trump to be put back on the ballot anyway, but they did not. So what are they saying? They are saying that an insurrectionist can, in fact, occupy the presidency, contrary to the wording of the US Constitution. Why did they not reason through this in order to vacate what the court said in Colorado? There's more. I'm with those of a different opinion. One came from Manisha Saina, CNN, while correctly pointing out that the 14th Amendment restricted state autonomy. The High Court, again, erred in claiming that the, quote, Constitution empowers Congress to prescribe how these determinations should be made. The expert says to argue that the states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency, is tantamount to claiming that the states have no power to uphold the Constitution. My point exactly. It bears repeating that qualifications to run for president and the constitutional disqualification of Section 3 of the 14th Amendment are self-executing. Self-executing. The Colorado Supreme Court did not enforce that disqualification. It simply upheld Section 3, Amendment 14. In their concurring opinion, the three liberal judges argued against a chaotic state-by-state patchwork that the Colorado decision would allegedly unleash, while chiding the majority for its lack of judicial restraint in ruling, not just in this case, but for all future cases, in the need for congressional legislation to enforce Section 3. So they are, at the end of the day, ruling the same way for very different reasons, is the point. And they're 5-4 on the split of the reasons. While the court's liberal justices rightly grasped that the majority decision would emasculate the constitutional disqualification for waging and abetting an insurrection against the U.S. government, they wrongly surmised that upholding the Colorado decision would allow each state to go their own way. Just as this decision allows Trump to be on the presidential ballots of all states, upholding the 14th Amendment disqualification would have meant his removal from the presidential ballots of all states, as during Reconstruction, when even Republican-appointed judges went along with undoing federal laws and constitutional amendments. The justices have also left us defenseless against future insurrection attempts. As they conclude, quote, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming president, end quote. It's a damn shame. And I'm going to say this for the record. These are supposed to be the brightest legal scholars. And sometimes I think they're too damn smart for themselves. This is common sense. It's an in-context ruling. Some justices are making the ruling based on current political dynamics. Other justices are making the ruling based on some potential future fictional dynamic that may happen at some point ahead. But nobody's making the decision based on the current context of the law. Sharon, thoughts here?
Well, I guess it's official. The Constitution, the amendments, it means nothing unless it's enforced, and it's going to have to be left to the people yet again. What the conservative judges did, as you so eloquently pointed out, was handcuff the rest of us and inch us even closer, maybe it's a mile, not an inch, towards not a democracy, but something far more scary.
Yeah, I'm sure there will be some element of discussion beyond this, but the court has basically ruled that you don't have to set aside the insurrection dynamic. A court can hold that you did in fact engage in insurrection, and the state cannot remove you from the ballot.